Many employers normally think that just because there was a misconduct, the dismissal is going to be straightforward. Well, in reality, that's not the case. As an employer, having a valid reason is not in itself enough. The question becomes, was fair procedure followed? How did you terminate the employee, even though you are justified with a why? 8 common mistakes employers make during the disciplinary process, and most importantly, how you can avoid them. For those of you who are new here, I'm Ruth Tanui, an advocate of the High Court of Kenya. I'm also the founder and managing partner of Ruth Tanui and Company Advocates. Mistake number 1, assuming that most employers assume suspension is automatic. Well, in reality, that's not the case. Before you decide whether you're going to suspend an employee where there is misconduct, you have to first ask yourself, is it necessary? For instance, if it's necessary to pave way for investigation, that makes sense. So you can give an employee suspension. Another thing you need to ask yourself, how long should the suspension be? Don't make the mistake of suspending the employee without a definite period. So if it's 2 weeks, give 2 weeks. And even though, let's say, the investigation go more than 2 weeks, you can give an extension. It's allowed. And then the other common mistake employers make is assuming that since this person has committed a misconduct, you're not going to pay them for the suspension period. Please note that suspension without pay is unfair. So you cannot suspend an employee without pay. Remember, at this point, it's an allegation. They have not been found guilty, even though it's an allegation, and that's why you need to first do investigation. So that's why you cannot suspend an employee without, at least, you can suspend an employee without pay. The second most common mistake employers make is giving out a vague notice to show cause. Please note that just giving out a notice to show cause is not enough. Courts have stipulated that the allegations in the notice to show cause have to be clear. Remember, you're bringing allegations against an employee. You must give them the allegation in detail so that at least they can respond to the allegation. So, for instance, if someone had been accused of absconding duty or maybe stealing company property, you have to make sure that you state that in detail, and when necessary, put the dates, where their emails mention them, if it's maybe poor performance, if the person had been put under performance review, make sure you stipulate that. Just make sure the allegations are so clear that the employee can easily understand and respond to it. Don't just say that you have been accused of misconduct. The third common mistake employers normally make is normally giving an employee a short period to respond to the notice to show cause. Remember, you are giving this person an opportunity to respond to an allegation. So you cannot, even courts have been clear that 24 hours is a very short period. Remember, it's not about taking a checklist. You have to make sure you actually have to show court that you actually gave this employee a reasonable timeline for them to respond. So that's why, from experience, I normally suggest 3 to 5 days. And this is just based on, and also just based on context. Give an employee 3 to 5 days. And so that at least the employee can have enough time. Because remember, you giving the notice to show cause does not mean the process is fair. Court will also find out what was the period timeline that you gave the employee to respond to it. This brings me to the fourth common mistake employers make. You don't consider the employee's response to the notice to show cause. Remember, again, you're not taking a checklist. You have to make sure that when you serve an employee a notice to show cause, you actually consider their response. Because the reason you're giving them the allegation or serving them the notice to show cause is for them to give their response. So that's why you have to make sure you look at the employee's response. Most employers will not even, I think from experience, I normally feel some employers even don't read the employee's response. Because sometimes you might have accused an employee for absconding duty. And this employee responds by letting you know that they were sick and they were in the hospital during that period. They even attach evidence. So see, if you fail to look at that and just proceed, it will be clear you didn't look at their response. So that's why it's very important as an employer to ensure that you consider the employee's response. Or it might be something that you may find an employee maybe committed a mistake or a misconduct that your policies allows them to be forgiven on the first strike. And maybe they're responding telling you, based on your policies, it allows him to be forgiven. Or maybe based on that they were in alignment with your policies. It's very important to consider the employee's response. Then the fifth common mistake that employers normally make is normally failing to inform the employee that they can be accompanied by a witness or an employee of their choice. Remember, under the law, you have to give an employee enough opportunity to defend themselves, even if it will mean they bring in witnesses. Most employers normally make the mistake of assuming that it's the employee supposed to ask for any witnesses if they want. No, it's you supposed to clearly stipulate. That's why most of the time for employers who consult with us, we normally advise them to even write to the employee that if you have, instead of just telling the employee, making a standard notice to attend a disciplinary hearing, telling the employee you can have you can bring a witness or an employee of your choice. You can even clearly state to them, if you have any witness or an employee of your choice you want to come with to the disciplinary hearing, please inform us maybe 2 days before the hearing or 1 day before the hearing, depending. You see, from that context, someone will see that the court will see. From that context, court will see that you are aiming to make sure you're giving this employee an opportunity to be heard. The sixth common mistake employers normally also make is failing to actually give an employee an opportunity to be heard. Most employers just do the disciplinary hearing as though it's just something. Again, it's just a checklist. Remember, you have to give an employee an opportunity to be heard. So that's why during the hearing, you have to make sure. I normally say the process should, it doesn't matter how you do it, but just make sure the allegations are read to the employee. You ask an employee, did you bring any witness? Put it on record. Or I normally say, ask the employee, were you aware that you're supposed to bring a witness? Let them say yes, and then you ask them, so you didn't bring any witness, so that at least you're protecting yourself to show that you already told them, or maybe make reference to your notice of disciplinary hearing to show that you asked them to bring a witness, and then now give them a chance to give their defense during the hearing and actually have it written, so that when you're making your final decision, you factor that in. The other seventh common mistake employers normally make is failing to provide evidence that they intend to use during the disciplinary hearing. Please note that if you have, especially for employers who clearly stipulate that they undertook investigation, you have to give the employee the investigation report. I normally talk about a famous case of some bank in Kenya who had a teller who had lost a lot of money for the bank. Of course, court found that the bank was justified to terminate him. However, they had done an audit. Of course, they did an audit to find out how much money the bank lost. But they didn't provide the audit report. They didn't give the employee the audit report. So despite the fact that court found that they were justified, they still went ahead to terminate. Despite the fact that they were justified, court found that the process was unfair. So it's very important that you provide any evidence that you intend to use. This is a common mistake that employers normally do. The eighth common mistake that employers normally make is failing to keep proper records. Remember, this is normally not a suggestion. It's the law. Employment Act of Kenya stipulates that employers must keep records. And as a result, employers get seriously punished if they don't, because if an employee claims something like overtime, and for you don't have records, most of the time, if you look at even cases of the Kenya law, most of the time the court will award. Because court normally assumes if you don't bring in the records, what the employee is saying is true. Because court assumes you kept the records, so you just didn't bring it because maybe that's why court will assume what the employee is saying is true. Even like for disciplinary minutes, some employers don't normally present the minutes. And so if the employer is saying the disciplinary hearing was unfair, court will go with the employer's argument. Court will go with the employee's argument. If the employee is saying the disciplinary process was unfair, and the employer doesn't provide the disciplinary minutes, court will go with the employee's argument. So that's why it's important for you to keep proper records. A lot of employers have been made to pay millions and millions of money in court just for failing to keep records. Remember, even though you follow these disciplinary processes that I've mentioned, and you don't keep records, like if you don't keep record of maybe the suspension letter that you provided, remember if the employee claims the suspension was without pay, or maybe claims that the suspension was indefinite and you don't have evidence, chances are the court might go with the employee. It's very important for you to keep records. Remember, as I've stated, it's not a suggestion, it's the law. So just know, as employers, please note that the disciplinary process is not only about misconduct, it's about also the process that you use while following through the disciplinary process. The other common mistake employers make is assuming that the disciplinary process must end on a dismissal or termination. please note that even though you are justified, there's a valid reason of a misconduct, you also have to make sure the process is fair. Like, for instance, I gave an example, you have to consider the employee's response. So put all the factors in consideration. Because I gave an example, let me give an example. There's a case I was handling for an employer. In their policies, they stipulated the allegation they had brought against the employee had 3 strikes. But during the process, the employee, this was the first strike for this employee. But unfortunately, the person who was handling the process forgot to consult their own policies. And so they had gone ahead to terminate. And you see, that is normally frowned upon by many courts. Courts frown upon employers who go against their own policies. Remember, I know most people, I think, have had for the 12 months compensation that court normally gives. It's normally stipulated as a maximum. So meaning court can even give 1 or 5. But the moment I know, from experience, I've seen whereby employer even goes against their policies, courts in most instances will even almost give even the maximum. Because it just shows that the employer disregarded the process and they had a predetermined outcome. So I hope you have found this video to be helpful. You can let me know in the comment section, what is the common mistake you see employers doing, from the ones I've mentioned or the ones that I've not mentioned.